Good morning, everyone, and welcome to the Read Longyear, Malnati, Corwin, and Burnett June webinar. Those of you that have joined us on prior webinars know that we do these periodically on topics that clients bring to us, common questions, or situations that we think would be helpful for clients to consider and be informed about. This is not intended to be a comprehensive answer to all questions on the particular topic, but just to kind of have an opportunity to talk and think about issues that clients are concerned about or might want to consider being concerned about. Each program is varied based on topics that have been coming up or that we think might be of importance or maybe in the news. So we do keep them on the website for past programs, and you're certainly welcome, invited to go to the website to watch some of the past programs and some of the topics that have been covered there. But today's topics are those that I think you'll find interesting and helpful. Anton Cauthorn will be talking about the probate to-do list checklist. That's a very common and important aspect when someone is appointed as a personal representative or executor or administrator of an estate on what to do. Following that will be a presentation by Greg Porter on insurance coverage and what that is all about, what that means. Then Lesley Novotny will be speaking on property status agreements. That could be a prenuptial, a postnuptial, or a cohabitation agreement. And then our last presenter will be Attorney Meng speaking on gifting. We get questions about gifting, and particularly with the sunsetting schedule for the current estate and gift tax law for the federal estate and gift tax system. It's a timely topic to consider as we plan for 2025 and beyond. So again, these webinars are continued on our website. So after today's program, if you have a question or want to go back, certainly you're welcome to go back to the website or to give us a call or email, and we can address any particular questions unique to your circumstances and needs. So without further ado, I'd like to get started with our first speaker, who's Attorney Anton Cauthorn. Anton, who some of you have worked with, is a estate and gift and tax attorney. He is a graduate of the University of San Diego Law School and then completed his LLM program at the University of Washington. And Anton will be speaking today on the probate to-do checklist. So Anton, do you want to get started?
Okay, thank you, everyone. I've got my screen shared now, and I will go ahead and start talking about the post-death checklist and really about what to do when a loved one dies. And this checklist, I'm going to be going through more than just what are all the legal procedures you need to be following. I'm also going to be talking about what are some of just the small practical things to think about after somebody has passed away to make sure we properly administer their estate. And so today we'll be going through some of those very basic things to some of those things that you may not think about after someone has passed to make sure it's taken care of properly. So let's go ahead and get started and look at what we should do and what is our checklist when somebody passes away. And before we even get into that, the basics we should all do is thinking about planning for death. Because what you do before you pass away can make it much easier for the person after your death to go through that checklist to make sure they take care of everything properly. And the first most important thing, of course, is to prepare your estate planning documents. Have your will, your healthcare directives, all of your documents in order. The next really important thing to do prior to passing away is have a conversation with your family about death and what should happen after you pass away. Because you know where your documents are, you know what your finances are, you know what your passwords are, but your family does not. And so preparing them to be able to find those things will make everything far, far simpler for them and make their life much easier. So have that conversation and talk about, where are your estate planning documents? Where are the originals stored? Because your family will need the original documents. Talk about where your passwords are stored. And if you don't have a good password storage system already that you keep up to date, now is the time to start thinking about that, because not having passwords after somebody passes away can create numerous nightmares. So create a good password storing system that's safe and secure, and make sure your family knows how to access those passwords if they need to. And that should include the password to get into your cell phone and the password for any important accounts. Next, creating a list of important assets. If your family doesn't know what you own when you pass away, it's very difficult for them to go through and find everything. Some cases are easier, some cases are more complicated, but having a list of everything that you own, all of your important financial information, debts, things like that, can make the process of administering your estate far simpler than it otherwise would be. Next thing to talk to your family about is, do you have a do not resuscitate order? So if you said, if you have a heart attack or a stroke, you do not want to be resuscitated, make sure your family's aware of that and where that document is. So if you do have a heart attack or stroke when they're around, they know what the proper steps to take are. Likewise with the healthcare directive, do you have a directive stating if you're in a permanent unconscious condition in the hospital, you would like to have treatments removed? So make sure you talked about that. And then also, are you an organ donor? If your family's aware of that, they can make sure they can inform the hospital of the proper choice. And then finally, one of the most important is, what should happen to your remains? Your family should know, do you want to be cremated, buried, composted, or hydrocremated, so that they do not accidentally do the wrong thing after you pass away? Because unfortunately, family members often don't find the proper documents until they've already had a funeral and done the ceremony. So having that conversation ahead of time and telling people your wishes is very important. All right, next step. And this is one that can be a difficult one to think about, because what do we do right when our loved one passes away? This is a difficult time where we're processing that grief that is so sharp because it's just happened. We've lost a loved one. Now, if your loved one passes away in a hospital or hospice, there's nothing you have to worry about. They will take care of the next steps of moving the body to the coroner. But if somebody dies at home, there is a question of what you do. And the proper step is to call 911. So if somebody passes away at home, call 911. They will send somebody to transport the body to the hospital where the coroner can examine the body and sign a death certificate. So if someone dies at home, call 911, simple stuff there. After that, what are the next steps you should take after someone passes away? And these are steps that we should take probably within, a few days to a week after someone's passed away. So we want to first contact their funeral home. Hopefully you have knowledge of what they want because you already had that conversation with the family. If not, you want to look for their documents to see if they had any documents stating what they wanted to have happen at death, whether it be burial, funeral, and also whether or not they paid for anything to happen at death. So look for those documents and then contact the proper funeral home. If there is not one, you cannot locate one, you and the family can decide. And also take time to grieve. You do not have to start the legal steps right away. There's nothing in the law requiring you to start things the day after somebody passes away. You can take time, and I usually say take, a few weeks to maybe a month or two before you get started. Now, some things may be time sensitive. If somebody has car payments or loan payments, you may need to do those quickly, but you can take a little bit of time to grieve before you start doing the legal side. Part of the step two should also be notifying friends and family, letting people know that somebody's passed away. And then, of course, if desired, you can prepare an obituary to have that posted in a local newspaper. All right, after the funeral, after that's been taken care of, we can start looking at doing some of the first paperwork steps. And here, the important thing is to start going through and finding all of the important documents, because those are going to be necessary to administer someone's estate. So you want to make sure you go through and you find someone's wills and trusts, and you want to try to find the original documents. To start a probate, we'll talk about it in a little bit, you must have the original will. We also want to look for any financial documents because we will need those to find their finances, to find out what they own. We also want to look at past tax returns because those can help us track down assets and find out if the returns were filed. We want to look at passwords. Again, we have to be able to log onto their account, so we need passwords. And then we also want to start checking their mail to see if there's anything coming in the mail that can help us ascertain what they own. And of course, also reach out to obtain a death certificate, either through the funeral home or through the state. And then one important step here that is easily missed that I have on here is find and secure the cell phone. And the reason this is important is because after someone passes away, we often need to gain access to different online accounts. And one common thing is if you're logging in from a new location, you often have to have what's called two-factor authentication, where there may be a text message sent to that cell phone, and we can't log in if we don't have that cell phone. And so what you should do is when somebody passes away, don't cancel their cell phone right away. Keep that cell phone running, keep paying that bill, because when you keep that number, and then if there's two-factor authentication, it'll get sent to that phone. And if we have the password to get into the phone, which hopefully we do, we can then get the authentication and log into the account. If we don't have the password for the phone, if we're still paying the bill, we can actually swap that cell phone number to a new cell phone that we do have the login to, and then use that to get two-factor authentication. But do make sure you secure that cell phone, make sure you pay that cell bill because you might need it to get access to online accounts. All right. Next thing we want to look into doing is making sure we secure someone's residence after they pass away. And this is important because, of course, there's a lot of things that can go wrong in a residence. If no one is living at a house, we need to be worried about things like hazards. Is there something that's going to cause a fire hazard? Is there gas running in the house? Is there a water leak that's going to cause some sort of extra bill? And so we want to walk through that house and do an examination to make sure the house looks safe and secure. And we also want to make sure we maintain utilities. We want to make sure the lights can turn on. We want to make sure the house stays warm. If it's winter, we want to make sure it stays warm enough so the pipes aren't freezing. So you're looking at that too. But on the other hand, non-essential utilities such as the cable bill, we may want to cancel that because we don't need to pay for cable anymore. And then also, of course, we want to make sure the home is locked and secured. We may want to change the locks if we don't know who has keys to that house. And we want to make the home look lived in. We want to make sure that somebody who's a thief passing by doesn't see a dark house day after day and think, wow, this is an easy target, I'm going to go in. So if you can add timers to lights, something to make it look like somebody is living there. And then if there are valuable items in the home, we want to make sure we secure all those valuable items, which could be artwork, antiques, and if someone has firearms in the home, that's even more important to secure. We don't want those stolen. And one useful thing to do is walk through the home with your video camera on your phone, take a video of everything in the home, because that's a quick, easy way to remember everything in there. And if there is a break-in and things are stolen, now you've got evidence for insurance to help prove what was in that house. Next, we want to secure the vehicle. If someone has a vehicle, we want to make sure it's parked somewhere safe and secure. Make sure it's not going to be ticketed because it's on the street. Make sure it's not going to be towed from its location. Look for things like, are there going to be pollen from trees dropping on it? Are there birds that are going to be pooping on this? Or is it in a theft risk location? So we want to see if we need to move that vehicle somewhere to make sure it's safe and secure so we don't have a loss of value there. And if there's an auto loan, we want to make sure we pay that because we don't want that vehicle to get repossessed and towed away. Next step is we want to start thinking about, well, what do we need to cancel after somebody passed away? And one thing to think about first, of course, is credit and debit cards, and also getting rid of any checks and canceling and blowing these out. We want to make sure there's not going to be any fraud on any of the accounts of the deceased person where suddenly we have bills going out that we weren't aware of, or payments going out that we weren't aware of, that somebody stole those cards. So cancel the credit cards, cancel the debit cards, and the checks. Also, any mailings, if there's newspapers or magazines, not as common as these days as it used to be, but if there are coming to the house, cancel these so you don't have an ongoing subscription fee. Same thing with online subscriptions. If someone's paying for Netflix, Prime, Microsoft, there's usually not a point in keeping these, and you can start canceling those to avoid those costs. Now, if the billing is automatic through someone's credit or debit card, well, the moment you cancel those credit and debit cards, it's also going to cancel those services. So sometimes it's a two birds, one stone situation once you get those, but it's still important to look for those. Now, one note on that, sometimes it is useful to maintain subscriptions. If someone says, let's say they have an Amazon Prime account and they purchased a lot of movies on that and other family members are still using it, well, maybe we want to keep that going and allow somebody else to continue that so the family doesn't lose that. So don't just cancel everything right away. Think through it and think, is anybody still using this account? Is there some reason to keep this going? And if there is, keep it going. If not, go ahead and cancel it. One other note on things that are important to keep: cloud storage. You want to try to keep the cloud storage going for as long as you can, just in case somebody had photos or other important documents stored online that you may want to access for family history. So be thoughtful about that before you cancel that as well. Next up is we want to notify organizations that somebody's passed away. So notify banks, financial institutions that they've passed away. And one note on this: the moment you notify a bank, it will freeze all of their accounts. Technically, they should be frozen when they pass away, but do know that someone's accounts will be frozen after you notify those financial institutions. Other places to notify, as we have up on here on the slide: register our voters, Social Security. Also, we want to notify the credit bureaus to prevent fraud, so somebody can't go out and try to get credit on the deceased person's credit. We also want to cancel their driver's license through the DMV. And of course, if someone's still working, notify their employer to make sure their employer is aware why the person is not showing up to work. Now, one thing I want to note on online accounts: there's a few different types of online accounts we do not want to notify that the person passed away because it can make things more difficult for this. This would be the email, any cloud storage accounts, and Apple is a really big one. And the reason we don't want to do this is they may prohibit you from accessing these, and they might erase all the data in the account. Apple's very notorious for doing this. You tell someone, or Apple, that someone passed away, and their policy is wipe everything on the account, and now you lose everything from photos to whatever else they had on there. And so before you access these accounts, there can be some interesting legal issues. I would advise talk to your attorney before you start trying to log in, and make sure you're doing everything the legal way. So there are some complications here. Talk to your attorney, but do not notify these accounts that somebody passed away because you may need to gain access. That could be harder if you've given them notification. Now, the next question is, well, when do you need to contact your lawyer? At what point in this administration? And my advice on that is within a few weeks to really a few months. And as you're going through all these steps I've talked about above, it is good to have the guidance of a lawyer. There's unique things in every single probate and administration of an estate, and a lawyer can make sure they guide you to be aware of those potentially unique or interesting situations. So try to talk to that lawyer as soon as you can to make sure they can assist you through the process and make sure you're doing everything right in that process after losing a loved one. Now, what that lawyer will do is they will help you get appointed to have the legal authority to administer the estate if you're the named personal representative in their will. And the way they'll do that is by starting a probate for you. And as long as you have a will, it's a pretty straightforward process. They're going to prepare paperwork for you. You will sign that paperwork. The lawyer will file all of that with the court, and the court will appoint you, giving you the authority to administer your deceased family member's estate. Fairly simple process here in Washington. Luckily, our probates are very quick and easy here. Now, once probate's been started, your attorney is going to guide you through this process, but you're going to need to start paying debts. And there's a specific procedure for that where you give notice to the different creditors. The attorney will walk you through that. You're also going to need to create an inventory, which is a list of everything the deceased person owned and their values. So you need to go through and find out every single financial account, life insurance policy, car, all of these things, and then find the value for every single one of those and create what we call that inventory. You're also going to need to take care of taxes. When someone passes away, they may have previous tax returns that were not filed for their last year of life or maybe even earlier. We need to file those. Also, there may be an estate tax if someone's net worth is high. Other things during probate, eventually we're going to need to clean out their home. We're going to need to go through and look at everything they have, need to sell or distribute to beneficiaries or throw it away if it's garbage, and then sell the home, car, anything else that needs to be sold. Then the final step of administering an estate is always going to be giving the money to the beneficiaries, but doing this is a complicated process, and this is one you should talk to your attorney about to make sure you're giving the money to the right people. Otherwise, you could personally be liable. So have your attorney view the will, contact financial institutions, review deeds, make sure you're determining those proper beneficiaries, and really work with your attorney to do this, to make sure that everything goes to the proper beneficiaries. And one note on this is something that can be very confusing. When someone dies, their will does not govern the beneficiaries of everything their own. So the will only governs the things that do not have what we call beneficiary designations. So if somebody has a retirement account with beneficiary designations, those beneficiary designations govern where the retirement goes, not the will. And that's why it's very important to have your attorney review all this to make sure everything is going to the right person. So that's it for my probate checklist here. I will go ahead and stop here and let Mike Longyear take back over and introduce our next speaker.
Thank you, Anton. That was super helpful and informative, and really a great checklist for all of us to think through, and particularly reminding people to update their documents so that their beneficiary designations are consistent with their testamentary plan and addressing the estate planning issues. Our next speaker is Greg. So thank you, Anton. Our next speaker, Greg Porter, practices in general civil matters, and he has a particular experience and expertise in insurance matters. And so today we've asked Greg to speak on when is enough insurance coverage. Greg is a graduate of University of Washington Law School and is active in various bar associations as well as with a busy practice. So Greg.
Thank you, Mike Longyear. And yes, good morning, everyone. As he mentioned, I'm Greg Porter. I'm a member attorney at Reed Longyear, and I have a bit of a unique expertise for the firm as part of my practice is in personal injury, which is actually how I started my career, and it's now part of my career here. And with Reed Longyear, I do plaintiff's personal injury. So I represent people who've been injured by others, whether negligently or intentionally, and that means I spend a lot of time dealing with insurance. I'm not an insurance salesman. I'm not here to sell insurance, but these are just observations I've had over the course of my career, because in my pursuit of getting compensation for injuries, getting justice, it depends a lot on insurance. And so what's available for people to recover really oftentimes boils down to what insurance there is. So in my lifetime of negotiating with insurance adjusters, suing insurance companies for bad faith, or advising clients on how to handle insurance claims, these are some tips and practice points I've found. So first thing first is that, unfortunately, unintentional injury is a quite common occurrence. Is in Washington state, unintentional injury is the third highest cause of death, and auto injury is the leading contributor to unintentional deaths overall. So you've got cancer, you've got heart disease, and then you have unintentional death as your leading causes of death. And then if you're looking at the value of insurance claims, so that's either the settlement or the court award after a trial for when people are injured unintentionally, is you see the value of that has increased by 2/3, about 66% in just the last 10 years. So that actually significantly outpaces overall inflation. So the amount of damages that people are settling for and being awarded is increasing drastically. And it's increasing a lot more on the high end. So at this point in time, is your average insurance settlement or award is just over $24,000. And then your average serious injury is approaching $500,000. And so if you think about what an average means, is that's everything from the most insignificant claim imaginable. You know, a plaintiff is in their SUV and they get nudged from behind by a golf cart and the paint isn't even scratched. That type of claim is in the average. And so you think about if it's going up and it's going up fast, that means that the types of injuries we see and the amount of insurance that people need to really get compensation for their injuries is increasing very, very fast. Now, as I mentioned, your average claim just broke $24,000. And that's a bit of a problem because the minimum policy in Washington state is $25,000. So your average claim is about to overtake your typical policy in Washington state, or at least your minimum mandatory policy in Washington state. And then that's someone who actually has insurance at that minimum of $25,000. And almost 1/4 of drivers in Washington state are completely uninsured. Even though state law requires any driver to have insurance, over 20% of drivers are completely uninsured. So you think about how many cases there are where a plaintiff is injured and the defendant has either no insurance or they have this piddly $25,000 limit, which barely covers your average claim and is only 5% of your average serious claim. So we have a very significant problem of un- and underinsured defendant drivers in Washington state. Now, you might say, who cares about insurance? Is you can just collect on a defendant's assets, you can garnish their wages, execute on their home, and technically those are options under the law if a defendant does not have adequate insurance coverage. But word to the wise is that those remedies are very difficult and often unsatisfactory. Is the state law provides a number of exemptions and exceptions to collections on a plaintiff's judgment. And the most significant is Washington state's homestead exemption. For most people, their largest asset by far is their home. And in Washington state, a defendant can protect the equity in their home from collections under a homestead. And the law says that the exemption amount is either $125,000 or the median sale price of a single family home in your county. And you get the larger of those two numbers. Now, the median sale price for a home is set by the Washington Center for Real Estate Research. They've published their numbers for 2023. And in every single county in the state, the median value blows way past the $125,000 number. The lowest is Lincoln County at about $250,000, and then San Juan Island County is about $1 million. Now, I live and practice in King County, which is the most populous county, and here the value is just under $900,000. So the overall weight of the counties is well over $500,000, oftentimes approaching $1 million. So this is a colossal exemption if a plaintiff is trying to execute on a judgment. And it really means if you're looking at the type of defendant who is uninsured or underinsured, they can usually protect their entire property from collections by invoking the homestead exemption. Now, another option is a plaintiff can seek to garnish the wages of the defendant, but state law also provides a number of exceptions and exemptions to that type of collections. As if a plaintiff serves a writ of garnishment, the defendant can deduct taxes paid for Social Security, any federal income tax, amounts paid to other liens like child support or a labor and industries lien. And then once all those are deducted, a defendant can also set aside a certain amount for disposable income. So the amount the writ gathers is shrunk and shrunk and shrunk by all these exemptions. As personal story is I've been working on a collections for a judgment against someone working in construction. And a year of collection efforts in the year 2023 yielded about $250 total for the entire year. And then collection efforts have continued into 2024. And so far we've gotten about $43. So that's less than $300 for a year and a half of collection efforts. And a writ of garnishment is only available for the plaintiff who takes their case all the way to court, who gets a judgment, and who prevails in any possible appeals. So that plaintiff is looking at years and years of costs and aggravation and dealing with lawyers and the stress of litigation. And then this is what they get to show for it. Now, I've chosen an extreme example, but it is a real example. And so if it is a worst case scenario, sometimes the worst case happens. So what should someone do? If you're looking at a state where there's a huge number of uninsured or underinsured drivers, and if your other remedies for collection as a plaintiff are dubious at best, likely unsatisfying, is then it's a matter of protecting yourself and protecting your own and family by having your own robust insurance. And so an auto insurance policy is broken down into three main pieces. The first piece is the liability insurance. So this is the insurance held by the person who caused the injury. So if you're the plaintiff, this is not what triggers. This is the defendant's portion of the policy that triggers. Or if by accident you were to cause injury to someone, then you are protected under your liability policy, as this is really the party responsible for pain, but the insurance company will only pay up to their policy limits. Now, the second major piece is what's called personal injury protection, or PIP. And this is part of the policy held by the injured person. And what this portion of the policy does is it pays medical bills upfront without regards to fault. They don't need to wait until a case is resolved, as even before you file a complaint, as PIP is obligated to pay medical bills. And this is extremely valuable, as I can assure you that a healthcare provider like Swedish Medical does not wait for an injured plaintiff to get their award from a jury. They want their medical bills paid now, and they will send it to collections even with a case pending. So having PIP protection so that those bills are resolved without you having to go into debt, without it going into collections while a civil case is pending, is invaluable. And this is a real trap for the unwary, is that in Washington state, insurers must offer you PIP, but you can choose to waive PIP coverage. And so a lot of times it's pitched as this insurance sale, is look at this great low price you can get. All you have to do is check this little box to waive this superfluous coverage. Think twice about that. If you take anything away from my words today, think twice about that, because this is extremely valuable coverage. It will save an injured plaintiff a colossal amount of grief, and it helps them remain financially solvent while the actual case and insurance claims percolate through sometimes long and arduous process. And then the third piece is uninsured or underinsured coverage. And this is another portion of the policy held by the injured person. And in Washington state, this is a mandatory component of any auto insurance policy. An out-of-state driver might not have this, but any Washington state insured driver will have this. And the way this works is that if the defendant is totally uninsured or if they have that minuscule $25,000 policy, or even a larger policy, but it's a very serious claim that the liability coverage is insufficient for, then the injured person's own insurance steps in and covers up to their policy limits. And this can sometimes be a painful process because your own insurance steps into the shoes of the defendant, so they will defend against claims as if they were the defendant, but at least there's coverage available. So you're not dealing with a deficit. But wait, there's other types of insurance that are also available. And one that really intrigues me is umbrella insurance. And so oftentimes this is offered as a global policy. So it's umbrella to homeowners, it's umbrella to liability, to auto, to UIM, just provides general coverage. And this is your third layer. So if you imagine a very serious injury, say you're that typical $500,000 serious claim, defendant has a minimum policy $25,000, so that gets wiped out immediately. And then the plaintiff has a UIM policy, but it's also insufficient. Maybe it's 50,000, 100,000. So then that gets spent in full, and you still have barely covered the true value of the claim. If that plaintiff has an umbrella policy, then that can step in and fill out the rest until there's been full compensation for the injuries. And umbrella can be quite nice because the value of the policy versus the price of the policy is you get really robust coverage at an affordable rate. Because again, they're the third layer. So they would only have to pay anything if the first two layers are totally exhausted. So it's often a good bargain to get an umbrella policy. And then there's other types of health insurance that have nothing to do with cars necessarily, but it may also be available for serious injuries. And these sort of function equivalently to the PIP in an auto policy, where they will pay medical bills up front, but all these types of insurance have what's called a subrogated interest. So at the end of the day, even if they pay bills up front, they get paid back from the ultimate settlement or award. And so it's really important that your counsel and you be savvy to make sure that those subrogated interests are protected in a total settlement, because especially entities like Medicare and Medicaid, they are relentless at making sure that they get their liens paid back. And so my advice would be it's better to have claims processed through a UIM and umbrella policy than worrying about protecting Medicare's subrogated interest. Sometimes it can be helped. Medicare just gets billed by the hospital and there's ways to work around that. But if we're thinking here today about how to be proactive, is the takeaways would be to absolutely opt in to PIP coverage, to make sure that the policy has robust UIM limits. I'd say certainly well above the state minimum, as if you look at your average serious claim, it's 20 times the size of the minimum. So absolutely insufficient. You really want a more robust policy, and then consider umbrella coverage if that's available. Thank you.
Thank you, Greg. That was super informative, and thank you for presenting it in a way that I think we all got some good takeaways from that. And a reminder to check on our insurance, make sure that we have the right coverage. Our next speaker is Lesley Novotny. Lesley joined the firm last November, and Lesley is very versatile because she practices both in the family law arena as well as the estate planning, probate and trust litigation. And so she gets to see how families and individuals interact with each other and the steps that one can take in planning for that, and then the consequences if they're not planned for. Lesley is a graduate of University of Pittsburgh Law School, near and dear to my heart, and delighted to have her presenting today on property status agreements. Lesley.
Thank you, Mike. Can you see my screen?
Yes.
Okay. Thank you. Okay. Thank you. So thank you for having me today. I'm going to talk about property status agreements. So I guess to start, we need to just talk about why do we even need to speak about property status agreements. here in Washington State, if you're married or living with someone in certain circumstances, we have in Washington community property. Washington is one of the few remaining states in the United States that has community property law. So in Washington, when spouses are married or if you're living together, partners can develop a community property interest in property that is acquired during that time that you're married or living together. So community property is earned income during the marriage. It's property that's obtained with a spouse's earnings during the course of the marriage. It's any property that is purchased with community funds. It's can be any inherited assets that are placed in a joint bank account. Anything that is jointly owned property would be considered community property. So it's all assets and debts that are acquired during the relationship, and then it is jointly owned by both spouses. Then we would also have separate property in the relationship, and those would be gifts, inheritance, property that was acquired prior to the relationship, or gifts and inheritance that was acquired during the relationship as well. So the community property, each spouse immediately owns an undivided 1/2 interest in all of the community property. So either spouse acting alone can manage and control the community property. And there are exceptions, and I'm not going to get into all the exceptions because we're going to talk about the agreements more in this talk. But the important part is that part of the reason that we want to talk about these agreements is that we want to know what we have the rights to do with the property and what we don't. And that's how we want to think about the agreements, is what do we want to change the rights to or keep the rights to when we're thinking about the property. If it is your separate property in the relationship, then you have the right as your own individual in the relationship to manage, lease, sell, do whatever you want with your separate property without your spouse's consent. The community property, you're going to have some more rules about that. So let's talk about the property agreements. Oh, and I skipped over the commingling. So commingling of your separate property could possibly convert your separate property into community property. Another reason why we're going to talk about the agreements is we want to make sure that we understand what we're doing with our assets in order to make sure that we're not turning a separate property asset into a community asset by commingling. So part of the reason we're going to have an agreement might be to make sure that we understand the rules of what we're doing with our assets to maintain the characterization of community versus separate. So some different status agreements are listed here on the slide. You might see these agreements named differently. Some attorneys and other organizations name things different names, and so sometimes it can get confusing. So I'm going to name them these in this presentation, but you might see, other than prenuptial agreement and postnuptial agreement, sometimes some of these agreements might have different names for the same type of agreement. So you just have to understand what's in the agreement, but they might have a different name. But the reason that we're even talking about these agreements is so that couples can determine how they want to characterize their property and how they want to own their assets in the relationship. And they can also then contract out of that default law we were just talking about in Washington, and or align their assets with Washington law with maybe just a few deviations. So each of the agreements have their own specific requirements. There is some statutory law that say the community property agreement, there is statutory requirements. Some are case law developed, and some are sort of things that we've developed over time in Washington to address needs. So if you're married, we have a few options. There's a community property agreement. There's what maybe might be called separate property agreement or property status agreements. There's a postnuptial agreement, which is essentially like a prenuptial agreement. It's just a timing of when you did it if you've already gotten married, but it has a lot of the same requirements and same parts as the prenuptial agreement, but you've just already gotten married. So if you're gonna get married, we might call it a prenuptial agreement. So, and then one that we're seeing a lot more of now in Washington is a cohabitation agreement or a committed intimate relationship agreement. And generally, they all are going to have the same characteristics, where they're going to identify the character or the ownership of property and then determine how the property is going to be distributed, either in the case of dissolution or death or separation of the parties. Oh, sorry, went backwards instead of forwards there. Okay, so we'll start with the community property agreement. This one's a little bit different. This is actually a statutory agreement that a couple might use. It's typically an agreement signed by spouses that's going to establish the character of all the existing assets and liabilities owned by the spouses and after acquire assets as community property. So this isn't used that often. You really want to make sure that it aligns with your estate plan. It's a very specific agreement that's used in specific instances. So you'll really want to talk with your attorney that's doing your estate planning to see if it's something that fits what your plan would be. But it is statutory based. So it essentially creates community property for the spouses instantly at the time of execution. It makes all of the assets for the couple community property regardless of their source. So even if your assets were separate property coming into the marriage, or you inherited some assets during the marriage, it just converts everything to separate property. And most of the time, although there's some exceptions, it creates an immediate vesting in title to the surviving spouse at the death of the first spouse, so that at that time of the death of the first spouse, everything title immediately transfers to the surviving spouse. I'm not going to talk too much about separate property agreements or property status agreements. They're a small part of my practice. I don't know that they happen much, but every once in a while, a couple might want to define an ambiguity regarding the character or ownership of a certain asset or a subset of property that they have in the marriage. So you might want to talk to someone if there is, for some reason, maybe there's been a commingling of assets, or someone's inherited something, and you want to make sure that there's no ambiguity as to how that asset is owned in the marriage. There is a way to do an agreement about that. But I'm not going to spend a lot of time on that because we don't have too much time today. But as far as community property agreements, why a couple might want to do a conversion to all property into community property is basically it's mostly for probate avoidance. It's because it simplifies the estate as entirely community property. It automatically transfers all the the surviving spouse is automatically the owner of all of the assets at the death of the first spouse. And so it might be useful. Why you might want to have one is it might be useful in a long-term marriage where all the assets you want to be community property anyway. But like I said, you really want to make sure that it fits with all of your other estate planning goals. If you have other tax planning or other aspects of your estate planning, it might not be the right fit for you. So you want to make sure that you really are speaking with your attorney to make sure it's the right fit. So the next agreement that we'll talk about is the prenuptial agreement or the postnuptial agreement, which, as I talked about, is basically the same thing. It's just a timing issue if you're already married. These are probably the most familiar types of property status agreements. Most people have heard of these. They're getting more and more common, even for younger people who are just getting married. They are essentially contracts that define community and separate assets and address how the assets will be divided in the case of divorce or death. So it's an agreement that's signed by the couples who are planning to get married. There are procedural and substantive requirements in prenuptial agreements that make them enforceable. So it's important that you work with an attorney because one of the requirements is that each party is represented by independent counsel and has an opportunity to understand the rights that they're giving up. Generally speaking, they need to understand what their rights and property interests are under Washington law, which we just went over quickly at the beginning of this, because they could be contracting out of rights that they may have under the property rules in Washington. So they need to be represented by independent counsel. There needs to be a full disclosure of assets. So each party needs to really understand what the other party has, what their liabilities are. If one party is in a lot of debt and the other one is not, what the other's income and expenses are. It's really important to have full transparency. That's one of the most important aspects so that each party is understanding exactly where the other party's financial situation is. There needs to be, each attorney needs to sign off that they have been fully informed and fully participating and have given each party their full explanation of their rights and interests, and that the parties sign in front of the notary. There's also an important aspect that it's done with a lot of time before the wedding, that no party is pressured into signing right before the wedding date, like that the invitations have gone out, the presents have been sent, and they were forced into signing, and that they would be embarrassed and have to return all the presents. And so it's really done under full understanding and without pressure. And that's an important part to make sure that it's not done with any undue influence to, well, I guess that's not the right term, but any undue pressure of signing, and that it's done with full understanding of what they're getting into. And then if it is signed, it will be honored by the court, and it is enforceable. So why you might want to have one, why they're helpful. It really offers the couple the opportunity to have conversations about money before they get married. I think it strengthens the marriage with the couples being able to have the uncomfortable conversations before they get married, and are presented with the real difficult financial issues that married couples face whether they're having to have those money issues or not. They oftentimes have to have those conversations about how they want to spend money. It increases a couple's ability to address those financial issues in a healthy way that eventually reduces the marital conflict. They also are able to learn about their assets and their property and their debts and how those would be treated under Washington law if they got married without the agreement. And so they're able to then make really conscientious decisions about how they want to treat those issues in their marriage before they get to that place. And I think it helps them understand what they want to do as a couple and how they want to process those conversations in their marriage. So they have a roadmap now of how they want to treat their assets and their future together already. So the other thing is it also provides a roadmap for distribution of assets in the case of divorce or death, which is helpful should they separate. Why you may want to have one, for all the above reasons, but also if one or both parties have significant separate property or inheritance entering in the marriage, it prevents confusion if the parties want to use separate property to make improvements on shared property or pay off debts or invest in joint ventures. There's an outline to determine how that will be treated. If there's any significant income disparity, it's defined as how that will be addressed. Any debt responsibility can also be addressed, especially if one person is more debt averse than the other. You can address family planning if one person may want to be a stay-at-home parent. It can protect the financial assets of that person. If they're gonna forego work to stay at home, possibly, it will ensure that they're provided for in the event of separation or divorce. If it's a subsequent marriage, maybe one or both parties have children from a previous marriage, it can protect their children's assets for future in case of divorce. It also can, if you co-own a business with other people, it can protect the other people's interest in the business as well as their business partners. So the next agreement is cohabitation agreements or committed intimate relationship agreements. This is one that we are seeing a lot more and a lot more need for. And I think it's probably one of the most important property agreements that we're doing to date. In Washington, we don't have a common law marriage, but we do have what's called a committed intimate relationships doctrine. And that's defined as a stable marital-like relationship where both parties cohabitate, knowing that it's a lawful marriage between them does not exist. So anyone who's living together with their intimate partner, knowing that they're not married, but they're living as intimate partners, and there's a series of requirements that you have to meet to prove the committed intimate relationship doctrine, which we could do a whole nother webinar on. But if you're living together as partners, putting yourself out there as if you're married-like, you can create community-like property interests in your acquired property. So it will be almost like you're married. So the community or the committed intimate relationship doctrine evolved to protect unmarried couples who acquire property during their relationship so that one party is not unjustly enriched at the end of the relationship.
So
the-
Leslie, this is such a great topic. I think let's hold this for maybe the next webinar and just
Mhm.
focus on cohabitation agreements and the important issues and considerations. So thank you for taking us through property status agreements and how
Sure.
important and complex they are.
Sure.
Okay. And our last speaker today is Attorney Meng Che. And Meng is a graduate of Seattle U University Law School and also the University of Washington LLM program. And so he really enjoys getting into the weeds, so to speak, on taxes and how they're treated for gifts as well as estates. And so Meng is going to be talking about gifting limits and timelines that we're all looking at as we look at the 2025 sunset of the current federal gift and estate tax rules. So Meng.
Excellent. Thank you very much, Mike. And can you confirm that you can see my presentation slides?
Yes.
Excellent. Thank you very much. And good morning, everyone. Thank you all for joining today's presentation. As Mike shared, my name is Meng Che, and I'm an attorney in the Reed Longyear Estate Planning and Probate Practice Group. In both practice areas, the topic of gifting and gift tax comes up quite often. And today, my brief presentation will provide a general overview of current gift tax amounts and gifting timelines with some practical considerations at the end. Before we dive in, I want to clarify that the presentation is for general informational purposes only and not legal advice. Attendees should contact their own attorney or tax professional to ensure the information provided is applicable or appropriate to each attendee's unique situation. Now, with the disclaimer out of the way, let's go ahead and dive in and make sure we're all on the same page about what a gift is. A gift is generally defined as any property that is transferred for less than adequate and full consideration. Thus, if a person gives money or property without receiving something of equal value or consideration in return, a gift was potentially made. Now, it is important to understand gifting because if gift tax is due at the federal level, the highest applicable tax rate is 40% of the gift, and the lowest is 18%. So that is significant amounts of potential gift tax responsibility, and it's typically paid, it's the responsibility and paid for by the donor of the gift instead of the donee who is actually receiving the gift. Now, however, before we get into gifting amounts that may expose a person to potential gift tax, it is helpful to know that the Internal Revenue Code does exempt certain gifts from the gift tax. These include gifts that are not more than the annual exclusion amount that we'll talk about in a little bit, as well as tuition paid directly to a qualifying educational institution for another person, and direct payments to medical providers for another person's care. And to be really clear here, we want to underscore the direct payments need to be made to those providers or qualified educational institutions. Those payments can't be made to the individual that is receiving the care or is benefiting from the tuition, such as through a reimbursement. Otherwise, those gifts would be considered invalid and would not fall under this exemption. Next are gifts between citizen spouses. So there's the unlimited marital deduction. Unlimited amounts can be transferred between spouses through gifting. And then last are gifts to certain political organizations for their own use, but restrictions do apply on that one. So it's a little more complex. And then also as kind of a reminder to people that there are charitable gifts to qualified organizations that may result in an income tax deduction, but several factors do apply to determine if a deduction is available to an individual. Now that we know what a gift is and how much gift tax can be and what is potentially exempt, we'll walk through the current gifting amounts that people can take advantage of without incurring gift tax. First, as most people on the webinar today are Washington residents, The good news is that generally Washington does not impose a gift tax on lifetime gifts. Thus, when making gifts, most Washington residents do not have to worry about any gift tax or reporting to Washington state. However, at the federal level, there is a lifetime unified gift and estate tax that thankfully also has an annual exclusion amount for de minimis amounts gifted in a year that is indexed for inflation. Thus, as inflation rises or falls, the annual exclusion will also fluctuate. For example, in 2024, the annual exclusion amount is $18,000 per individual. And for context, in 2023, the annual exclusion amount was $17,000. So within the span of 1 year, between 2023 and 2024, the annual exclusion amount increased by $1,000. And that's significant in terms of the amount that people can gift. Next is that to be aware of is that couples can also combine gifts to a single individual. So while one person in a marriage can gift $18,000, if the spouse joins in the gift, they can then combine the total amounts together to that one person to be $36,000 in 2024. That means then that gift is not subject to the estate tax, and no potential gift tax return would need to be filed for that gift. And something to keep in mind here is these annual exclusion gifts, as long as they're below that amount, nothing needs to be filed and no gift tax would typically be due. Now, if a person wants to gift over the annual exclusion amount, a person will usually have gift tax exposure for the amount gifted over that year's exclusion amount. However, a person that has not done any prior gifting typically has their full federal lifetime unified gift and estate tax exclusion available, also referred to in some literature as well as by other professionals as the lifetime exemption. That is also indexed for inflation and was temporarily doubled by the Tax Cuts and Jobs Act back in 2017 and is now currently at $13,610,000 for 2024 and could potentially increase in 2025 as well. Thus, a person can gift up to this lifetime exclusion amount and not pay any gift tax. However, the lifetime exclusion amount is set to automatically reset downward to pre-Tax Cuts and Jobs Act levels if Congress does not act by the end of 2025. The reset amount is estimated by some tax professionals to be in the $6 to $7 million range, which is still quite high for a lot of individuals, but is significantly less than this year's exclusion amount. Also, if gifting more than the annual exclusion amount to a single individual, as I alluded to earlier, a gift tax return or an IRS Form 709 typically needs to be filed to document the gift and if any tax needs to be paid, or if a portion of an individual's lifetime exclusion is being used instead. If anyone is wondering what would happen if someone opted to use their entire lifetime exclusion amount this year, and then the amount resets downward in the future, the IRS confirmed in a 2019 news release and through subsequent regulations that it would respect individuals who use up their entire lifetime exclusion amount in a given year before it resets downwards. Thus, if no gift tax was due previously for a prior gift, no future gift tax should be due just because the lifetime exclusion amount resets downwards. Next, I want to touch on timelines and provide some additional considerations for attendees. Gifts need to be completed by December 31st of the calendar year that the gift is going to be claimed in. And if a gift tax return is required to be filed, even if it is only informational, if no tax would be due because an individual is using their lifetime exclusion amount, it will be due the same date as the federal income tax returns, or typically April 15th. Thus, people have a lot of time to make gifts and file any corresponding gift tax returns if necessary. However, I usually recommend people engage their tax professional or a financial advisor or planner early in the year, not only to confirm each year's current annual exclusion amount, and to share any planned gifts for the upcoming year, especially if the gift will be over the annual exclusion amount. This puts the tax professional or advisor on notice if a gift tax return will need to be filed, and if any information regarding cost basis may need to be shared. And that leads to kind of the first consideration, which is that while gifts are valued at their fair market value as of the date of the gift, if the gifted item is an appreciable asset, let's say like a residence or a home, and there's significant appreciation over the years, the person receiving the gift also receives the carryover cost basis of the donor at the time of the gift. Thus, while they may be receiving a gift, there may be significant capital gains tax exposure that may be transferred as well. Next, and related to the previously mentioned fair market value at the time of the gift, certain gifts may require professional valuation to determine fair market value. Many experienced professional evaluators, especially for small or closely held businesses or other niche specialties, are usually booked well in advance and may not be able to provide needed valuations to complete a gift for a month or more. Thus, pre-planning for non-standard gifts should be done to ensure that gifting is in a given year will go smoothly. Last, with a likely lifetime exclusion reset at the end of 2025, many people may be contemplating intensive gifting in 2025 that may rely on professional evaluators and appraisers that further exacerbate our timelines. Thus, there may be even higher demand for those professional evaluators and appraisers next year because everyone's rushing to make lifetime gifts. So something to be aware of. And so the key takeaway really here, and it's kind of a major theme, I think, throughout multiple presentations today, is, that people should engage with, their professional tax personal tax professionals or other professionals, advisors each year and early to plan efficiently for any upcoming gifts. This will help ensure that any issues or concerns can be addressed in a timely manner and that gifts can be completed as well. With that, I've come to the end of my presentation, and I thank you all for listening. As the topic can be quite complex, we can answer any additional questions in the question and answer session that's immediately following and will be proctored by Attorney Mike Longyear. Mike, over to you.
All right. Thank you, Meng. That was a really interesting and complex but thoughtful presentation on this issue of gifting limits. There is a question in the chat about the materials being available to those of you that are logged in, and they are available. Just reach out to us and we can send you the slide deck, and then the seminar itself will be posted on the website probably in about a week once we do some editing. And then are there any other questions out there that we can ask our panel today?
If there are questions, individual attendees can type them into the question and answer at the bottom of the screen.
Did any of the panel have any questions for each other? I guess on the gifting, it is important to understand that the 18,000 annual gifting amount is per person receiving the gift. So hypothetically, parents could give 18,000 gifts to children and grandchildren times 2. So up to 36,000 a year before filing that return per person receiving the gift. And that could be used for funding an educational account for grandchildren, or helping with a down payment for a home, or any reason that a gift is wanted to be made. And of course, reminder with a gift is not a loan. So once a gift is made, you can't ask for it back. So it's important to look at the consequence of the gifting and make sure that there are protections in place so that gifting to minors in particular is in a custodial account or education account, if that's the intent of the gift to those minors. Okay. Well, seeing no questions, thank you all for joining us today, and thank you for our panel of presenters. And we'll be planning another program a little bit later in the year, so watch your inbox. And again, the prior webinars and today's webinar will be on the website, and you're invited and encouraged and welcome to do it. And of course, anytime you have a legal concern or question about how estates work or insurance works, or any of the real estate related questions or family law issues that come up, please reach out to us.
Yeah.
And with that, have a
Mike,
good day.
quick suggestion here is
Okay.
if attendees have any specific questions or burning topics for a future webinar,
Yes.
I think that if they are working with any of our attorneys, feel free to reach out to any of those attorneys and make suggestions for any future webinar content, as well as we do have our email address at the firm, info@reedlongyearlaw.com. People can send emails to as well.
Thank you, Meng, for that reminder. And again, you're invited to make any suggestions for additional webinar topics or questions that you may have, whether it's real estate or family law or estate planning or probate or trust administration, insurance, personal injury claims, and anything that we can help you as an individual or your family or your business with in addressing your legal needs. Thank you so much. Have a great day.
Thank you.